Submitted May 25, 2023. Motion for recusal. Now comes Maurice Stringer, the moving party in the aforementioned cause, and hereby respectfully requests the recusal of the Honorable James W. Coffey, the presiding Boston District Court judge, from this case, based on the following: in accordance with Article 29 of the Massachusetts Constitution Declaration of Rights, footnote, given the explicit protections provided by Article 29 of the MA Declaration of Constitutional Rights, as emphasized by the S.J.C on numerous occasions. See, for example, Commonwealth v. Leventhal, 364 Mass. 718-721, 1974. Beauregard v. Dailey, 294 Mass. 315, 324, 1936. King v. Grace, 293 Mass. 244, 246, 47, 1936. Thomajanian vs. Odabshian, 272 Mass. 1922, 1930. Art. 1029 imposes a higher standard for judicial conduct compared to the Due Process Clause of the 14th Amendment, and the grounds that the judge's impartiality might reasonably be questioned because the judge has a personal bias or prejudice with respect to this case presenting a conflict of interest. Judge James W. Coffey went to Boston College and graduated from New England Law School, along with Wendy Murphy. Both graduated class of Boston College 83 and New England Law 87. Wendy Murphy's son, Grant Ellis, a.k.a. Grant Smith, a.k.a. Grant Edward Ellis, is the main witness in the Boston police report for this case. Both Murphy and Ellis reside in the same residence on Stone RD in Belmont, MA. Even though Grant Ellis, by his own admission, was not at the scene of the incident, he told the security guard that he was. As such, he became the key and central witness of the police report. Grant Ellis is a longtime friend and business associate of Harry Jean Jacques and David Jean Jacques, the two other men involved in this incident. Grant Ellis is also paying Harry. Wendy Murphy's son, Grant Ellis's statement, was used as the witness testimony in the Boston police report. The full video footage and the statement from attorney Cheryl M. Powell, who was an eyewitness of the entire incident and who provided her information to the officers on site, were not included in the police report. The full video shows David and Harry assaulting me, attempting to throw me off a second-floor balcony, and ripping my hair out of my head, with Harry dragging me across the floor, jumping on top of me, and swinging some type of weapon at my head. A close friend of theirs said that Harry and David were paid to attack me and have paid another woman to attack my wife. The mere fact that I am here 2 months after the incident where I was attacked by them on video at a very public place, and I'm in court while they are being called victims, is further indication of my rights being violated. This system waited 2 months to try and figure out that I allegedly committed a crime. But the two individuals who attacked me and maimed me aren't charged. The court sent 2 police officers to my home already, charging me without sufficient evidence and relying on the Boston police report, whose key testimony is from an individual who did not witness the incident in question, whose mother has connections with Boston police and the district courts, and who has a personal vendetta against me, violates my right to due process. These charges lack a proper foundation and fail to meet the legal standard for initiating criminal proceedings. Yet here we are, indicating that this summons and the criminal charges are motivated by discriminatory factors, violating my right to equal protection under the 14th Amendment. Such differential treatment lacks a rational basis and constitutes unfair prosecution. Grant Smith's mother, whom he lives with, Wendy Murphy, is intrinsically connected in this Boston court and district office as a former prosecutor, TV personality, and local law school professor. She conducts criminal exposés and currently has a working relationship with the Boston police, as well as the clerk magistrates, clerks, and the district attorney's office. I've contacted the Attorney General's office to have Internal Affairs look into this and have attached a copy of that letter to this motion. For these reasons, I am requesting your honor's recusal. Respectfully submitted.
This is the very first motion I submitted almost a year ago. I submitted this motion at my arraignment, motion for recusal.